Under Minnesota law, a misdemeanor is a crime that is subject to the maximum possible penalty of up to 90 days in jail and a $1,000 fine. Common misdemeanor offenses include things like a first-time DWI, a first-time violation of an order for protection or harassment restraining order, a theft case involving goods valued at less than $250, or a simple assault. In misdemeanor cases, it is a city attorney as opposed to the county attorney who is going to be prosecuting on behalf of the state. That prosecution will involve a number of court appearances, including the first appearance, which is known as an arraignment. At the arraignment hearing, the court will make sure you understand your rights and what you've been charged with, and that you have adequate counsel. Following the arraignment, the matter will be set on for a pretrial conference where we can contest the admissibility of certain evidence or engage in plea negotiations with the state. If we reach a plea agreement that is acceptable, it'll be placed on the record, and then the matter will usually move to sentencing right away. On the other hand, if we can't reach a plea agreement, the matter will go to trial. Many potential clients are under the false impression that because a misdemeanor is less serious than a felony or gross misdemeanor, that it isn't justifiable to have a good defense lawyer involved. Well, keep in mind that very often we are able to obtain a plea offer that is much more favorable than an individual can obtain on their own from the prosecutor. Many of the plea agreements that we have reached call for either no jail time or a minimum fine or a reduction or dismissal of the various charges that have been raised. The second point is that despite the fact that some misdemeanor cases aren't necessarily that serious, they are enhanceable, meaning that a conviction now or a plea to a misdemeanor now can result in some consequence later if you face an additional charge.